going to call to order the Board of Zoning Appeals meeting for October the 16th, 2025. At first, we're going to confirm that we have a quorum that is present this evening. If I call your name, you can just say present. Priscilla Voigt.
Present.
James Street.
Present.
Durante Rollins. Jeanette Washington. Sharon Vikstrom. And David Rababi. All right, we do have a quorum. 5 of 6 members are present. So with that being said, we are going to go into, we need to first adopt the agenda. You have the agenda before you. If there's no changes or additions to the agenda, do we have a motion to adopt the agenda?
Move to adopt.
Is there a second?
Second.
All in favor?
Aye.
Aye.
Any opposed? Okay, with that being said, now we're going to go to item 1 on the agenda, which is the organizational meeting. So the first item is election of a chairman. We're going to open the floor for nominations for a chairman. As you know, Mr. Satterwhite was our former chairman. He was a member of the BZA for quite a while, but he has stepped down from this role, so we're going to elect a new chairman. Are there any nominations? The floor is open.
I would nominate David Rababi.
All right, are there any other nominations? Do we have a motion to appoint Mr. Rababi as our chairman?
So moved.
Is there a second? All in favor, say aye.
Aye.
Any opposed? With that being said, I'm going to turn the meeting over to Mr. Rababi.
Thank you very much. I am not nearly as articulate as Leo, especially when it comes to, I don't know if it's Robert's Rules of Order or whatever it is, but, and of course, I forgot my paperwork tonight, so compound. But, so let's see, our organizational meeting, we've done that. Now we're coming to our regular meeting, correct?
No, we need to go through. We've elected the chairman, so now we need to elect the vice chair.
Okay.
And adopt the rules of order and so forth.
All right, do we have a nomination for the vice chair? Thank you, ma'am. I'm sorry about that. Sorry about that. Nobody wants to be the vice chair? Come on, guys.
I'll volunteer if no one else.
Perfect. We have a second?
Second.
Okay, all in favor?
Aye.
Aye.
Opposed? Motion's carried. Adoption of the rules of order. I think we had some changes to the rules, did we not?
That is correct.
Okay. Did everybody have a chance to look at the changes that were highlighted in red? Let me rephrase that. Did anybody not have a chance to look at it? Does anybody need time to review? I think the only thing that was, we were discussing, Sharon, I think was the time. Did you want to change that to 6 instead of 6:30 or?
Like to.
Okay. Does anybody have an issue with 6 as opposed to 7?
So, Mr. Chair, if I may,
Please.
so the time of 6 p.m. was previously proposed when we discussed this back in 2024. And at that time, it was decided to keep the meeting time at 7 p.m. So this set of rules of order that you have is proposing a compromise in between the two meeting times. So the draft that you have in your packet is proposing a time of 6:30 p.m.
Yeah, I got that. Thank you.
All right.
As I recall, when we last discussed it, some of the members had trouble with a 6 p.m. meeting time, being able to get here on time. It's not a problem for me personally, but I don't know about the other members. Oh. So can all the members make a 6 p.m. start time?
I would say that 6:30 would be the earliest for myself, comfortably.
Okay. 6:30, everybody okay with that?
Yes.
Okay, we'll stick with the 6:30 change that's in here. Thank you for the input. And then the only other change was under 5, public hearing protocol. So paragraph 6, the applicant or applicant's representative must be present at all the hearings. And then staff presentation. Anybody have a problem with that, an issue with that?
No, mine's more so for number 8 that was added. I did have a question more so than, before it was set at a minimum or maximum of 15 minutes. I
Right.
understand they're gonna need more time. However, I've been to, unfortunately, a lot of different BZA meetings in different counties, recently. And the issue is not having a maximum because, some applicants sometimes talk for like an hour, 45 minutes, and that's a bit more. So I would say it max at the discretion of the board or discretion of the chairman, something along those lines to make it so we are not sitting here for an hour and then get lost in the sauce and we don't stick to proper policy procedure, because that's what we're about. We're not about all the detail, all that extra. So that would be my only thing is, yes, go ahead and say, a minimum of 15 minutes, a maximum at the discretion of the board, or a maximum at discretion of council. I'm not sure what would work best, but something of that nature. So we just don't end up here.
No, I
4
agree. I
hours.
think it's a good point.
Yeah.
I would think if you leave it at the discretion of the board or the attorney, that it opens you up to claims of being capricious and not being consistent. I would rather see a set time for the maximum.
Oh, thank you.
Okay.
Yeah, so what are we thinking for a maximum of time? Is there anything that's either in state code that is a guide for something like this? Nothing?
Not that I know of. Another locality that I served as zoning administrator at had a maximum time of 25 minutes.
Yeah, I think I'm okay with that.
I would agree as long as there's language to say that applicant shall not exceed a certain amount of time, 25 to 30 minutes. 15 minutes you should be able to get your pitch, but shall not exceed,
Mhm.
Yeah, I think that, can we rewrite this paragraph and instead of saying a minimum of 15 minutes, because then if somebody's only got 5 minutes, they're gonna feel like they have to talk for 10 more minutes. So can we just say a maximum of 20 minutes or 25 minutes? Can we do
Certainly.
Well, what would
Mhm.
I think we need to give him a more direct answer. So which number should we go with? Should we go with 25? Or do you want to go with 20, or, you know what I mean?
I'm fine with whatever the board wants to do.
25 is fine with me.
Okay, 25?
Okay, we'll go 25. Does that work for you? Yeah.
I'm fine with that.
Okay, so we're gonna change it, saying, instead of saying, be allowed a, 15 minutes, instead of saying at a minimum, how about we just add the verbiage to say no more than 20 minutes,
25.
or 25 minutes, I'm sorry. I don't know why I got 20 minutes in my head. Thank you.
So a question. So I'm presuming the statement would read, or the language in the document would read, applicants or representatives of the applicant will be allowed a maximum of 25 minutes. Was it 20 or 25?
25.
A maximum of 25 minutes to introduce information regarding the matter advertised for public hearing.
That's correct.
Okay.
Okay, any other, the only other changes, the real change, I think, is in the application. Specifically calling out planning and, community development. Anybody have an issue with that? Okay, so we'll go ahead and make a motion. I think we make a motion to, adopt the, rules of order with exception to the change that we identified, otherwise the changes are good.
Mr. Chairman, I would move we adopt the amended rules of order as originally mailed and as amended here tonight.
Second.
All in favor?
Aye.
Any opposed? The motion so carried. Okay, establishment of the date and times for the regular meeting. We were just saying earlier, this is our first meeting for this calendar year, I believe. So I guess it's been a quiet time at the county. Does anybody have any issues with any of the dates presented? I see we have November and December as TBD. I'm assuming that's because of the holidays. Does staff have any recommended dates for November, December?
Not at this time, but as you know, we have reached out to you about scheduling a meeting on October 28th of this month in
Right.
order to hold a public hearing. That meeting is underway and been advertised and scheduled, so we would ask that you would add that to the calendar as a meeting date, October the 28th, 2025.
And we're changing that from 7 PM till 6:30 PM, correct?
If you would like.
Yeah, please.
I believe we may have already advertised the time of 7 p.m.
Okay, if that's the case.
So we will stay with 7 p.m. For October the 28th.
Okay. Okay. So does anybody have any preferred times or times that they're not going to be available in November or December? Any of the board members? Let's see, we have Thanksgiving on the 27th. We have Veterans Day on the 11th. Yeah, so will I. I'm going to Jamaica.
I'll be out from the 13th through the 21st myself. So-
Okay, I think that's the same time I'm out as well.
Okay.
It sounds like you are too.
I think we're the 19th. We can do the 13th.
Okay.
Back with you on that.
I won't be in town on the 13th.
Neither will
Okay, I won't get back to you.
I.
How about the 25th, 26th, days before Thanksgiving?
That's fine with me.
That works for me.
Okay, so why don't we try for the 25th of November? We'll just pencil that in, and this is obviously only if it's not a Thursday, but that's because Thanksgiving's Thursday, so. And that's only if we have a case to come forward. And then for December? I'm gone the first week of December.
I'm good anytime.
I agree with that. First week.
You want to do it the first week?
Yeah.
I'm gone the first week.
Oh, you're gone. Okay.
I-
Okay. I misunderstood you.
No.
I thought you went for
How
it.
about the 11th of December?
That would work for me.
That's a Thursday?
Yes, ma'am, Thursday the 11th.
Let me.
Okay,
The only input I'll have, we can leave these dates as placeholders. We will just need to check on our end as staff
Right.
to confirm the meeting space is available.
yeah,
Okay.
no, I got it, yep.
Now, one thing I did want to bring out, and I hadn't mentioned directly, was about us doing the third Thursday. If we continue to have the meetings live stream, I do know they're occupied on that Thursday. Is there an issue with moving it to the second Thursday of the month?
Not with me, there's not.
Still
No,
keep it
I-
on Thursday, no time change, but just move it to the second? How am I so sure?
Are you guys okay with the second Thursday as opposed to the third Thursday? I mean, it doesn't,
We're not competing with any other county
We,
board.
we would have to verify that the
confirm,
room is
yeah.
available on the second Thursday.
Yeah.
okay,
As of right now, the room is consistently held on this date of the month for the BZA.
Right.
so are we okay with leaving that for the time being and they can get back to us and let us
They would
know?
need to check first.
Okay, all right, thank you. Okay, so, the establishment of the rules, I'm sorry, of the dates and times, we have a motion for that?
Yes, I move we adopt the dates and times as provided in the package with the amendments to include the addition of the October 28th meeting at 7 PM, as well as November 25th and December 11th, if the space is available.
Second,
Second.
okay, all in favor?
Aye.
Any opposed?
Question, they were gonna check about moving the dates, because that would be changing the dates that are on listed.
Right,
So if we
So-
adopt it as presented, then we're keeping the dates listed.
We will, and then if they come back and tell us the second Thursday's fine, we can
Okay, so
cross that
the-
bridge at a later date. If we change it now and then we have to change it back.
No,
it'll
I'm
just
more
be-
so trying to confirm that the wording of the wording's correct that he used. That's all I want to confirm. Like, we're good with what the wording is for his motion? Yeah, it works?
I'm
Okay.
comfortable with that.
Okay,
yes.
yeah, that's the part I was trying to confirm,
Okay.
not changing it. Yeah.
No, okay, all right, good.
Okay.
All right, next on the agenda is the, close organizational meeting.
I would move we close the organizational meeting.
We have a second?
A second.
Okay. All in favor?
Aye.
Any opposed? So I guess I just realized what I'm forgetting to do before taking a roll call is asking if there's any discussion. I think that's what just triggered my mind here. So is there any discussion? Okay, I figured if there was, someone would interrupt me and slap me
Yeah.
about. Okay. Okay, so, with that, we are done with the organizational meeting. And we can, proceed to the regular meeting and call for order. We are looking at the minutes from April 26, 2023, July 23rd, 2023, and May 16th, 2024. Has everybody had a chance to look at those that were provided by county, by staff?
Yes.
Any issues with any of the minutes?
I read through them, but I wasn't on the board at that time, so I'm just going to abstain when it
Okay.
comes to the vote.
All right.
Would you want separate motions or one motion?
I'm fine with one motion. Less bureaucracy, the better, as far as I'm concerned.
Okay. I would move we approve the minutes as mailed for the April 26, 2023 meeting, July 23rd, 2023 meeting, and May 16th, 2024 meeting.
Second?
Second.
Okay, any discussion of any of the previous meetings? Mr. Satterwhite is gonna be greatly missed. I'm sorry. I'm sorry he left us. Okay, so with that, all in favor?
Aye.
Any opposed? Okay,
And then one abstained.
and one abstain.
Yes.
Very good, thank you. Okay, new business. MC Dean Inc.'s request for a deferral. I'm kind of confused here. What, they're asking for a deferral, so why did we have to have a meeting? I'm confused. What,
This is just a formality, so I don't know if
Okay.
there's a lot more information I can add beyond what was provided in the packet, but as part of submitting their application, the application submittal included a request to hold off on scheduling a public hearing and making a decision on the request. So just to make this official, I have the BZA Act to accept the applicant's request to defer this application. That was the purpose for placing this on the agenda.
okay. Is there anything in the county regulations that set a time limit on this, or is it indefinitely deferred for?
No time limit
Okay,
to my knowledge.
okay,
I believe the time limits come into play once a public hearing has occurred.
okay. Any other questions?
Would you happen to know where they are in the special exception process?
This special exception application has been received, but it is still under review. It has not,
So it's not scheduled for a public hearing yet or anything?
correct.
So deferring it for another year would be appropriate, or less time or more time?
Well, they just asked that it be deferred until further notice. They didn't specify whether they needed several months or a year or,
So the ball's in their court or the county's court?
theirs as far as the special exception application that's under review.
Okay. Did that answer your question?
Yes, it did. Doesn't give me a warm fuzzy feeling, but it answered my
Yeah,
question
me
too.
This is a little confusing. I don't think we've had anything like this in the past, but, all right, any further questions or comments? All right, can we get a motion to,
I'm a little reluctant to defer it until the applicant comes back to us. I'd rather defer it for a specific time period. But I know special exception process can take a while.
right,
That being the case, I would move that we defer this item for 1 year.
Okay. Is staff okay with that from a legal perspective or from an administrative perspective?
I'm not aware of any issues with that to my knowledge. I'd have to check with our counsel.
Anybody have an issue with deferring it for a year? Let's kick this can down the road. Okay, no, so can we get a motion to defer it?
I would move that we defer action on this item for a year.
So do you want to say up to a year or for 1 year? Because if we defer it for 1 year, that means they won't be able to come back to us till October of 26, if I'm hearing you correctly. If we say up to 1 year, they could come back next month.
If they get their special exception, they can withdraw the application themselves, correct?
Correct. I believe that is their intent.
Okay. So I would say a year.
Okay.
Okay.
All right. Any other comments? All right, can we get a motion to accept this?
Okay, I'll try again. I would move we defer action on this item for a year.
Okay. Any discussion, further discussion? All right, all in favor?
Aye.
Any opposed? Motion so carried. All right. And we have work session BZA 101. I'm not quite sure what that is.
I'll try to explain the purpose of this being on your agenda. So as you know, the Board of Zoning Appeals doesn't meet as frequently as some of the other county bodies do. So as a result of that, sometimes members and staff need a little refresher course on procedures and the roles and of the Board of Zoning Appeals and you know what their role is. So we have with us tonight Mrs. Tracy Gallaire. I still got it wrong. Mrs. Tracy Gallaire from Sands Anderson. She offered her services tonight to come and give us a brief little training on BZA procedures. And so let me just read a little bit of information about Ms. Gallaire. Tracy is a seasoned local government attorney who advises counties, cities, and other municipalities on the full spectrum of legal and administrative matters. Based in Manassas, she brings nearly 3 decades of experience to clients across Northern Virginia and throughout the Commonwealth. With deep experience serving Virginia localities, including a long-standing role with Fauquier County, Tracy understands the unique challenges and responsibilities that local governments face. Her practice includes advising on day-to-day governance issues, land use and zoning matters, community development initiatives, and a broad range of litigation matters. So with that, I was going to turn the floor over to Ms. Gallaire to come forth, and she has a presentation for you all. Hopefully you all find this to be a wonderful learning opportunity.
And I know it's late in the evening. I'll talk quickly and move pretty quickly through these slides so everybody can get out of here and get to bed or have a late dinner or whatever you need to do. Staff's going to set me up with a PowerPoint presentation here in a moment. I'll let them get going. Do I have a clicker, or can I just ask you to advance slide when we're ready to go? Okay.
Tracy, will you be attending any meetings we have as council, or will there be other council?
So I am not serving as a counsel to the BZA.
Okay.
I am counsel to the staff in Caroline County. All right, do they see the slides even though I don't see it behind them? Okay. There we go. Okay. All right, if we could just move one slide, please. So really going to talk about the powers and duties of the Board of Zoning Appeals. First, I will rule out if there's ever any determination or interpretation pertaining to proffers. Note those go to the legislative body, in this case the Board of Supervisors, so you all don't hear those. And there has not been delegated legislative authority for this particular BZA to hear special exceptions or any type of special use, conditional use permits. There are two things, one of which you did today, and that is fixing your schedule for regular meetings. You can create a backup date for each of those dates that you establish for your regular meetings in your calendar as you establish it for the year. There is some benefit into doing that because if you have a backup date for inclement weather, they don't have to re-advertise for a public hearing. Things just move to your backup date automatically. Should there be a snowstorm, the locality needs to close and your meeting gets canceled. So that's something for you to consider in the future should you want to enable that. You also can establish your bylaws, rules of procedure. You all went through those today, so you know that. You can elect officers, a chair, a vice chair, and a secretary. I was speaking to staff before the meeting about secretary. I know you don't have one. You can elect one. It can be a non-member of the board and a member of staff. And it's something that staff may talk to you about in the coming months to help make things go a little quicker, smoother, would allow letters to be sent out, minutes to be signed by somebody on staff in the office, and the chair and the vice chair wouldn't have to take time out of their day to come in to get some of that administrative stuff done. And then finally, the BZA also has the ability to interpret, yes.
Sorry, let me ask a quick question. Who wrote these minutes, previous minutes? I'm sorry? I can't hear you.
Mrs. Zeck.
Oh, Lisa did? Okay. All right, so I mean, thank you. That answered my.
You also have the ability to interpret zoning district lines. Typically, when I do these trainings, I mentioned I've done this for 30 years, and I've never run across one of those. And over the last few weeks, I've talked about one of those. So they don't happen very often throughout the Commonwealth, but it is out there as a possibility. Somebody's got a piece of property. ComDev staff says you're zoned agriculture, and they believe they are a different zoning category. You have the ability to come to this board and say, "What is my zoning district?" Although most counties try to discourage or prohibit split zoning within parcels, it happens sometimes. So sometimes where exactly the line splits a parcel can be a question, and this board would have the ability to make those determinations. But we can move to the next slide. The main part of our discussion are going to be the two big key things that this BZA has the power to do, and that is decide appeals. And there's two different types of appeals, and then variances. So we're going to spend our time this evening concentrating on those two big key duties. There's two different types of appeals that you may hear. That is appeals of a determination by an administrative officer or appeals by a decision of a zoning administrator. 99% of them are going to be a zoning administrator determination or a zoning violation notice, a notice of violation and corrective order, sometimes abbreviated NVCO in the code. So when we discuss appeals further, I'm just going to refer to zoning administrator or ZA as an abbreviation for zoning administrator in future slides. But just note there may be another administrative officer within the locale that makes a determination that someone has the ability to appeal to you. And in that case, for the future slides, just consider when I say zoning administrator, it could be that other administrative officer also. Next slide. So for appeals, prior to the hearing, what do you need to know about prior to the hearing? Your hearing has to be set within a reasonable time. Notice must be provided in accordance with the Code of Virginia. It has to be advertised as a public hearing. That has changed in recent years in the Virginia Code. BZAs around the state didn't routinely hold public hearings for appeals, but changes to the Virginia Code have necessitated not only advertising the public hearing, but holding a public hearing on appeals. It's an odd thing to do because it really is an appeal of, I got this letter, the zoning administrator stands up and says, this is why I made the determination. The appellant stands up and says, well, this is why I think he or she is wrong. Why would you need to be able to hear from anybody else? Well, because the code requires it. So unless it is a particularly impactful zoning violation case where you have a variety of neighbors that have impacts associated with the use, you typically won't have a huge crowd come stand at the podium to speak on your appeals. Prior to the hearing, you can't have ex parte communications between the parties and any of the BZA members. The parties to an appeal are the staff. The staff is the one, the zoning administrator made that determination, so you can't have private conversations with zoning staff and community development, nor the attorney, nor anybody from Sands Anderson, Chris McKenzie, or myself with any BZA members related to that appeal. You all in this capacity are like an appellate body. You are quasi judicial. And so you're treated that way in terms of like a judge. You wouldn't have conversations with either side to that appeal before you made your decision. If there are any inadvertent conversations or information that's given, anything that's given to the BZA has to be given to the other side of the appeal within 3 days. Note, it doesn't change any other FOIA timelines with regard to responding to document requests and what have you. That is purely a faster delivery of document deadline for appeals specifically when information is distributed to the BZA by either the appellant or staff. Next slide. During the procedure, the zoning administrator or other official, they must go first to provide an explanation for the basis of their decision, determination, whatever's being appealed from. The zoning administrator's decision is presumed correct under the Code of Virginia, and you must presume it is correct. It is the applicant's job to meet the burden to overcome that presumption of correctness. Each side has to be given an equal amount of time to present their side of the appeal or their case. I will tell you in a lot of jurisdictions, I just did an appeal in the town of Occoquan. The BZA there decided that both sides of the case got 5 minutes to present their initial appeal. So keep that in mind when thinking about 25 minutes. You don't necessarily want lawyers on both sides of an appeal to stand up and take largely an hour arguing why a determination is made. Sometimes there are very complex factual determinations on certain types of violations or certain determinations that you may need a little more time, but you have to submit a statement of justification for your appeal, and staff will submit a staff report as well, justifying the determination they've made prior to the meeting. So you have a lot of written materials already before the meeting starts. People shouldn't need a half an hour each side to rehash that. They're just going to stand up here and read their written submitted materials and perhaps waste your time. So keep that in mind. As I said, the applicant bears the burden of overcoming the presumption of correctness of the county staff. That is a preponderance of the evidence standard. Is it more likely than not that the zoning administrator is correct? Also think about it, it has to be greater than 50% likely. Your decision needs to be based on your judgment as to whether or not the BZA or the zoning administrator was correct in his or her determination. You can consider whatever ordinances, laws, or regulations went into the basis for that decision. But what you should not be doing is placing your judgment in place of the zoning administrator's judgment with regard to how to interpret the ordinances. That's the zoning administrator's purview. And they are entitled to that presumption of correctness in their judgment on interpreting those regulations. Next slide.
Can we back up just a second, please?
Mhm.
I'm kind of confused. We've been doing this for a couple of years now. And this is the first time I've heard an attorney tell us to presume that the zoning authority is correct. I thought we were kind of, and it's kind of conflicting with what you said earlier. We've tried to remain unbiased and impartial, not taking one side or the other. So I'm getting conflicting, I'm hearing conflicting scoop from you.
It is a code requirement, and it should you decide against a zoning administrator and there be an appeal of the determination. It is part of what the court takes into consideration when deciding whether to overturn the BZA judgment. It is well-established Virginia law that zoning administrator or other officials entitled to a presumption of correctness in their determination. And you have the appellant have to have the burden to overcome that. What that means is say the appellant comes in and makes very little argument other than, I just think this is wrong, and presents no evidence, gives you no valid arguments as to why they think they're wrong. The zoning administrator is presumed correct. The appellant has not met their burden because they've presented little to no evidence as to why they believe it's wrong. The zoning administrator is entitled to be upheld.
Understood. Thank you.
Next slide. I would note that this is both a Virginia Code provision and it's also in the Caroline County zoning ordinance. No provision of this section should be construed as granting the board any power to rezone a property, or here's the phrase that's important, or to base board decisions on the merits of the purpose or intent of local ordinances duly adopted by the governing body. You may not agree with the policy choices that the legislative body has made with regard to the whatever ordinance we're interpreting or trying to decide on the basis of. It's not this BZA's job to make those legislative policy decisions. You may not like, I don't think we should have to regulate that. I think everybody should be allowed to have a dozen junk cars in their front yard. I don't like telling people they can't do that. That's not this BZA's role. You have to take what you're given by the legislative body and the regulations they've adopted. They're elected to make those policy decisions, and you're not allowed to base your decision on the fact that you just don't agree or want to regulate in that particular area. I would also note, and you can leave it on this slide if you like, I would also note that in addition to this limitation with regard to don't step into the legislative arena, don't look into the merits of whatever policy decision they've made to regulate or not, you also have no power to decide whether a zoning ordinance is constitutional, whether it should be enforceable. You know, did the lack of enforcement of it for a few years mean it's now waived and it's not allowed to be enforced anymore? You're not allowed to take those things into consideration. You're solely given a zoning administrator determination on the basis of a zoning ordinance where they said, I was asked for this interpretation, and I've decided that based on what they're asking to do, that particular use is not permitted under our ordinance. Here's our ordinance. That was my decision. You're not allowed to take a constitutional argument or a waiver argument into consideration and overrule or invalidate an ordinance. So you have to take the ordinance as it's written. Don't look in behind lawyers on both sides may bring forth arguments of occasionally an appellant on a violation case will try to bring in an illegal search and seizure. Well, they didn't have a search warrant for my property when they came out and found all those junk cars in my yard. You do not take into consideration any of those constitutional arguments or rule on whether or not a search was valid. You take the zoning administrator's opinion that they have evidence, and they used that evidence, applied it to the ordinance in question, and was, based on the evidence I had, I correct finding that person in violation for having junk cars in their front yard. Confusing?
Not confusing, just kind of a little nervous here. I mean, you're saying that we shouldn't take the Constitution into consideration?
You are not to.
I mean, the amendments of the Constitution, the Fourth Amendment, the 14th Amendment, these are perfectly straightforward and understandable. Maybe your example of search and seizure was a bad one. We've never had anything like that I recall. But
There's a case out of Prince William County on the search and seizure that was appealed to the Court of Appeals, specifically on the issue, almost identical, with regard to whether or not the zoning staff had Fairfax County, sorry, not Prince William County, Fairfax County, whether the zoning staff had properly obtained a search warrant before going out and finding a zoning violation. This is a civil proceeding. Any of the illegal search and seizure prohibitions, the requirement for a search warrant, only apply in criminal proceedings anyway. These are civil proceedings for civil zoning violations. The example of search and seizure comes up because you're gathering evidence from somebody's property. The reality is most of the zoning violation properties are all going to be within plain view on someone's property. You only have the protection of advance search warrant from having to be obtained outside of the curtilage of within the curtilage of your home, so the very boundary around your house and within your home. You don't get it for the entirety of your yard or your farm anyway. So it's really a non-issue. Sometimes, even if it was a criminal violation, by the way, sometimes the appellants in an appeal will bring it up just to have something to argue. But no, you all do not make constitutional decisions. You would not rule, well, we're going to throw out this evidence in the zoning administrator's case because we don't believe the search of the property was constitutional. You cannot base your decision on constitutional grounds. You need to look at the evidence as presented to you by the zoning administrator. Oftentimes it's a determination or interpretation of the ordinance that doesn't involve gathering evidence on someone's property of a violation. And in those cases, sometimes the constitutional arguments that come up are equal protection under the law. Well, my neighbor half a mile up the road has junk cars in his front yard and nothing's happening to him. And that violates equal protection. You don't take those into consideration. If there is a constitutional argument to be had, that's to be had against the Caroline County Board of Supervisors in a judicial setting at a later date, but not before a BZA on an appeal of a determination. And in appeals, staff will have cases. I can't address specific case law with you generally in a training like this today, especially since you have an appeal pending on your agenda in the near future. But there is specific case law that absolutely clarifies that this body doesn't decide whether or not, just like whether or not it's not good policy to have that regulation. You don't have the power to decide whether or not that regulation is enforceable, whether or not it's been waived due to not applying it evenly amongst all residents of the county, whether or not somebody's equal protection rights have been violated for the fact that violation notice has been given to them, but not other similarly situated properties. This board doesn't have that within your purview to be able to base your decision on that.
So what are we doing here?
We are strictly for policy and procedure. We're looking at this case, this evidence, and deciding if this evidence outweighs this one. If it doesn't outweigh it, then that's it. We're not getting involved
I
emotionally
got that.
or
I got that.
anything.
And we've been doing this this is my third year of doing it. So it's not
Right.
like this is my first meeting or first time doing this. I'm just concerned when you say things like, and we're very fortunate. The county has never, in my opinion, violated the Constitution or any regulation as far as I can recall. I'm just a little nervous. I mean, I spent my life defending and supporting the Constitution of the United States against all enemies, foreign and domestic. So when you say something about, we're not here to
Because
consider somebody's
like all
constitutional
of that will be
right, then what are we
addressed, just
doing
not
here?
addressed with us.
So you obviously don't want to violate somebody's constitutional rights, and you need to behave on the board and as a board appropriately as to not violate anyone's constitutional rights in your business. But you cannot take a constitutional argument to invalidate the county's ordinance. You're strictly looking at the reasoning by the zoning administrator as to why a determination was made or the evidence that a violation was found. And you're looking at that discrete information, applying it to the wording of the ordinance, and is that individual right or wrong? That's your sole decision.
Okay.
Not, does the ordinance violate the US Constitution? That's not your job, that's a court's job.
No, I understand that. I got that. I'm just saying though that it was a little disturbing for me to hear you say something about not taking the Constitution into or somebody's constitutional rights into consideration. 'Cause
The
if that's the
Constitution.
case, then you can fire me right now.
the constitutional right that comes up that this board would at all remotely be getting any close to any line is someone's due process rights. And that is, do they have a right to a fair hearing? And that's part of the public hearing process, the advertising, the notices requirements before the meetings occur, the fact that your meetings happen in the open. That would be the only one I could conceive of. I suppose you could be, discriminating against individuals, but that due process right would be the only one that would really be at all at risk. And obviously, staff helps keep both the advertising and the notice and what have you in line, so that you don't even get close to that line. The rest of the individual's rights that they're going to assert and appeal are usually where they're going to claim the ordinance itself violates the Constitution. Well,
Right.
it's not your job to
No,
determine whether the ordinance is right or wrong, either on policy grounds or constitutional grounds. A court needs to do
I
that.
got it.
Somebody wants to invalidate it, they need to bring a declaratory judgment action against the county, not an appeal of the zoning administrator's determination to you.
Understood. Thank you. That clarifies it.
Next slide, please. So what goes into your decision-making process? We went through what happens before. We talked a little bit about what happens during. What you all should do. You should gather facts and applicable rules with regard to the appeal. Identify how much discretion you have and who has the burden of proof. We talked about the fact that the zoning administrator presents first. They're entitled to presumption of correctness. The appellant has to overcome that presumption. You then need to understand and weigh all your available options in the appeal. And then make your factual findings. You need to establish a good record for the decision. So you need to make your factual findings. You need to have your discussions establishing that record for decision publicly. There is no closed meeting that you can go into to discuss and deliberate and decide on the appeal. That all happens in a transparent, open meeting. It establishes the record as to why you're deciding the way you are. And then you need to communicate your decision in the form of a succinct motion. In the case of, next slide, an appeal, you really only have a couple options and the motion's easy. You're either reversing the decision or you're affirming it. And you can do that either wholly or partly or modify it. You need to be careful with the modifying it because you don't have the ability to make a wholesale own determination of your own. But perhaps there's in that partially affirming the zoning administrator's decision, there's a correction that needs to be made. So you're partially affirming it and then you're correcting it. But the modify is not free reign for the BZA to scrap the decision and make your own. So the motion on an appeal is fairly easy. Move to affirm the zoning administrator. Second discussion vote. Move to reverse the zoning administrator, overturn the zoning administrator's determination. Second discussion vote. I would note, in order to reverse a zoning administrator or other administrative official's decision, or to grant a variance, your two main powers, you need a concurring vote of the majority of the BZA. And that's the majority of the composition of the BZA, in your case, 7 members, even though right now you only have 6. So it takes 4 votes in favor to either grant a variance or to overrule that decision being appealed from. If there's only 6 members present at the meeting, 4 of you are a quorum. If there's only 4 of you present at the meeting, and it has to be unanimous, all 4 of you have to vote in favor of overruling the zoning administrator. If you want to affirm, that can happen on a vote of 3-1. But if you want to overrule the zoning administrator, it requires 4 votes to do that. It requires 4 votes to grant a variance as well. If there are 6 members present, or like I said, 4 show up and you're a quorum, and there's a tie on appeals, not on variances, on appeals, the appellant can ask that their appeal be carried over to another meeting in hopes that perhaps in the ensuing month, either another member can make it to the meeting, or perhaps somebody has a change of heart or a change of mind. I note the code says may, so it is not they have an absolute right to a deferral to the next meeting on a tie. The BZA still has the ability to vote on it, and if you are intractably tied and no one is going to change their mind no matter the passage of time, a tie vote is the death of the appeal. It is an affirmation of the zoning administrator because you failed to get majority to overturn. Next slide, please. On appeals, you have 90 days from the date of the filing of the application to make your decision. I noted earlier on a slide, you have to timely schedule a meeting. This is where, you know, the timely scheduling it is important because you need to give yourself some time to have the hearing, perhaps have it deferred for a month. That 90 days is not mandatory. You don't lose jurisdiction or the ability to make a decision. The applicants and staff can agree to extend the time period. If you are in a meeting agreeing to extend and go past the 90 days, my advice is to get the parties to agree to that on the record. If you're doing it in advance of a meeting and you're not in a public meeting where you're making a record, then get them to commit to agreeing to extend that 90 days in writing. Okay, variances. And I will go pretty quickly through variances because I'm going to work with staff. I've already given some of the documents. My suggestion on variances, because there's a lot of criteria, there's going to be a lot of things that have to be determined for each variance that we're going to go through here in a minute, is to use a worksheet. And I have prepared a worksheet for other jurisdictions, and I'm going to work on that in coming weeks with staff to make that happen. I also recommend staff preparing example or pattern motions for you on variances that give you the ability as you're going through the criteria to circle, check mark, cross out, and it makes your motions easier, makes things smoother, and you make the appropriate findings that you have to make that record on the variances. And we're going to work on that in the coming weeks.
We had one from our previous attorney, and I don't remember what happened to it. But I remember having it in front of us as we
Yeah,
would go
I
through.
think I have them right here, Dave.
Okay.
If they would be of use to you, otherwise we'll just wait and see what you come up with.
With staff, if you can get the past ones that you've used, and we can do a comparison and come up with the best form. So as a result, if you all work through that method, if you're used to using that as a method, I'm going to breeze through these pretty quickly.
Okay.
Groups that don't use that and have to come up with these motions are often asking me questions and writing things down in notes from the dais when I go through these. If you're using a worksheet and you're using a pattern motion, then you know the required findings are all going to have to be made by you, and you're going to state them on the record. So I'm going to go through this part a little quicker, if that's okay. So a variance. A variance is defined as, oh, I'm sorry, that next slide. It'll be that was just your authority to grant a variance. A variance is defined as an application for a reasonable deviation for provisions regulating shape, size, area of a lot or parcel of a land, or the size, height, area, bulk of a building or structure. So let's talk about that very briefly for a moment. It's not a use of the property. It's something that relates to the physical requirements of a lot, setbacks, for instance, front yard setbacks, side yard setbacks, et cetera. It can be height restrictions. It could be, depending on an ordinance, some localities have maximum of impervious surface on a lot that's allowed to be covered. You could be asking to vary an impervious surface maximum. And it only applies when the strict application of the ordinance would unreasonably restrict the utilization of the property. And such need for the variance would not be generally shared by other properties. So if your variance is to a rear yard setback and you have a little subdivision where everybody's house is set about the same spot in the lots, and this individual wants a rear yard setback so they can put in a big mega garage in their backyard, if every single house in the neighborhood is all absolutely identical, that would be generally shared by other properties. And it is not appropriate to grant a variance in that circumstance. In that circumstance, the individual's remedy is for the neighborhood to come to the legislative body and ask for a legislative change. Hey, these setbacks are too restrictive and prevent us from being able to utilize our properties. We ask for a zoning text amendment to, reduce the setbacks. If you were to grant a variance for the guy in the middle of the neighborhood for his garage, it's just going to encourage others to say, well, he didn't have to comply with the rear setback. You gave him a variance, so I want it too. And then eventually, slowly and surely, you have made a legislative change to the zoning ordinance house by house by house by granting variances in a one-off fashion to everybody. So that is specifically in the criteria for what is appropriate for a variance to prevent BZAs and the grants of variances becoming an alternative to seeking a legislative change when it's fairly widely applicable. And then you can't grant a variance for something that would be contrary to the purpose and intent of that particular ordinance. Setbacks create space for light and airflow between properties. The absurd interpretation of that is grant a variance of a 0-yard setback, or grant a variance for the height restriction such that a neighboring property has all of its light blocked out for the great portion of the day. That would sort of violate the purpose of having the height restriction or setbacks. And then, as I said, you can't grant a variance for a change in use. It has to be something that's more related to the physical attributes of the property. Next slide. So the first test of a variance, you'll have 3 criteria. One of these 3 things at a minimum needs to be met. There may be a time when more than one of these are met. That's okay, but at least one of them has to be met. If you can't find one of these 3 things, you're supposed to deny the variance. And part of these are an incorporation of that definition. We have the unreasonably restrict the utilization of the property again. That the granting of the variance would alleviate a hardship due to physical condition relating to the property or improvements at the time of the effective date of the ordinance, or granting the variance would alleviate a hardship by a person with a disability, essentially. I would note on the disability criteria, variances are not time restricted, not restricted to an individual applicant. Yes, you can have a garage, but only for as long as you own the property, and then the garage has to be torn down. You can't do that. Except in the case of a variance for the ADA requirements for the person with a disability, you can restrict that variance for their improvement for the time they own the property or for the time in which they're disabled. For instance, somebody needs a variance to have a ramp in the front of their home, and it's going to really reduce the front yard setback to nothing out to the sidewalk to be able to have the wheelchair ramp. You can say that it's conditioned such that should an individual in the house no longer require a wheelchair ramp, or you no longer own the property, the wheelchair ramp has to be taken out, the variance is extinguished. You don't have to do that. And you may grant it for an indefinite period of time. That's going to be on a case-by-case basis based on the type of variance being sought. Depending on where the wheelchair ramp is, some wheelchair ramps may be more intrusive than others. Perhaps you're okay with it for a limited period of time, but it would be really bad to see that wheelchair ramp blocking something for a really extended period of time, and you want it to have to go away sometimes. I've seen a BZA grant a variance for a garage for an individual who was severely handicapped in a very large electric wheelchair that took extraordinary measures to get in and out of his vehicle. And he needed a enclosed area in which he could get out of his home and get the doors open and get loaded in and out of the vehicle. So wanted a carport or garage and needed a variance to the setback in order to build that. Now, perhaps with the expense that goes into building a carport or garage, that's not something you'd necessarily make them have to take down once that individual is either not there anymore or no longer handicapped. But it's out there as a possibility. Next slide. Now, of the next 5 criteria, all of these things need to be met. So the first 3, it's you only need one. You may have more than one, but you only need one. These last 5, every single one of them needs to be able to be met, or you don't grant the variance. The hardship was not created by the applicant. In that first criteria, I would note that there is case law in Virginia that says if somebody bought a piece of property knowing the only way they could develop it would be able to get a variance, that is not a hardship created by the applicant. They still acquired the property in good faith, and you can't say they violated that criteria. There was a BZA case in recent years where an individual had torn out a staircase on a piece of property. I want to say near Lake Anna. To develop the property, he tore the staircase out. Now all of a sudden, well, I need a variance in order to be able to build a new deck or staircase for ingress or egress. Despite the fact that he's the one who tore it out without looking into the requirements first, the court said that was still good faith and not a hardship created by the applicant. So that one is really hard to violate under Virginia law these days, and is a very low bar for the applicant to have to meet. Your second criteria is it's not a substantial detriment to adjacent property. Like I said, really close to the setback, obscenely high building that's going to block out all the light from the windows in the neighboring house. You may determine is a substantial detriment to the adjoining properties, and such that it's not appropriate to grant it. The third criteria, it's not so general or recurring in nature to make it reasonably practicable to amend the ordinance and make a new regulation. That's the discussion we had over a neighborhood where all the houses are similarly situated. The lots are all, perfectly rectangular and they're all the same. And this guy needs a variance for a garage. In that case, that's fairly widespread. Everybody's about the same. That's really you got to go to the legislative body and ask that the regulation be changed. That's not appropriate for a variance. Next slide. The granting of the variance does not result in a use not permitted on the property. We've talked about no use variances a couple times already. And then the relief sought is not available through a special exception process instead of the variance process. So if for whatever it is this individual wanted to do, Caroline County has decided that they will have a legislative approval process for your ability to have a structure closer than 25 feet to a side yard. In that case, even though that would be something that would perhaps traditionally be able to be applied for as a variance, in that circumstance, because they have adopted a legislative process, a special exception process for that particular type of setback variation, you can't decide it as a variance because a special exception is available to them. And that is it, unless you have questions.
Thank you, ma'am. Are these slides going to be made available to us?
Yeah.
They absolutely can. I have emailed them out electronically. If you would prefer printed versions, we can get them to you.
Okay, thank you. Any questions or comments from anybody on the board?
No.
And like I said, we went through that variance really, really quickly, and we'll be working on some worksheets and some pattern motions that will make that much easier for you. You get to each one and have they met this? Is that what this means?
You did a great job. Thank you.
Yeah, I like that.
Thank you for the presentation.
Okay. Staff have anything else?
Again, we thank Mrs. Galera for traveling to be with us tonight and
Yes.
give that wonderful presentation.
Thank you.
I just meant to mention earlier, I meant to introduce to you our new zoning technician, Rebecca Bradford, who's been sitting at the table here. She moved into that role towards the end of last year sometime, and so you may be seeing her more and receiving contact from her periodically as far as scheduling meetings and packets and whatnot. So I just wanted to officially introduce Becky to you all.
Thank you.
Thank you.
Becky, I know we spoke via email recently. I don't remember what my county email address is or password or any of that stuff. Can you help me? I don't know if everybody else is in the same boat or not, but we haven't met in so long that I honestly forgot.
So I'm glad you brought that up. Just we are communicating with the board now through the county email address only. So, Mrs. Lisa Zach had prepared an instruction sheet of how to access that email. If you need us to send that to you again, just let us know, but we'll be glad to guide you through
Yeah,
it.
if she could send it, at least I need it from my personal email so I can access the county email.
Okay, all right.
If, you know, that may not be a bad idea just to send it out to everybody.
Okay.
Thank you.
But it should be as simple as my understanding is you just put that website link into your browser and then you log in with the username and password that was on the sheet that Mrs. Zach emailed to you, and then you will be required to create a new password. And then from there on, it should be easy to access the account.
Thank you.
I haven't been able to since Windows 11 has been installed. So I've got to get help, which I've
Okay.
already had contact with the county. They
Okay, okay.
to help me figure it out.
Okay, okay. If anyone has any trouble, we are trying to work with IT, it's staff as well, and trying to make contact with you so we can start making use of those email addresses. And just be sure to check those email addresses. While this has been somewhat of a quiet year, there has been a little bit of activity within the last, I would say, 60 days or so. So we may be having to meet more um, from now through the end of the year and early into next year. So just try to check those email addresses once you're able to access them. Just check them regularly.
Okay.
Thank you. Anything else from anybody? Our attorney mentioned something that I was gonna ask. Do we need to look at alternative dates? Or do we just handle that on a case-by-case basis? I mean, for inclement weather, we get a snowstorm, the county shuts down. I'm just assuming the county would go out with a county-wide blast telling everybody the county's closed, any meetings held for this particular date due to inclement weather. Is that something we need to put in writing, or is that just kind of a given?
So if you are changing your date at the date of the storm, not establishing it as an inclement weather date that becomes loaded on the calendar after your organizational meeting or your annual meeting, they would have to re-advertise anything that was previously advertised for public hearing. If you set a calendar of dates for the year and you say on this particular date, if there's a snow day, here's our alternate date, and that's established in your calendar at your meeting tonight, or you can do it next month when you establish that calendar and publish it. That holdover date, that date that the inclement weather makes you run to, the second date, they don't have to re-advertise everything for public hearing. It just automatically moves to that usually it's like a week later or 5 days later. Oftentimes Thursday nights rooms are booked for other public bodies, and you might not be able to move to just the next Thursday.
Can we take it to the next regularly scheduled meeting?
You can absolutely, if inclement weather cancels a meeting, just cancel it. That still gives them plenty of time to re-advertise it for public meeting at the next meeting. You just have to note that on your appeals, you have that 90-day
Right.
time frame. I don't think this body's going to get deluged with 10 appeals a month over the course of the next year,
Right.
such that, and Virginia's not that bad in terms of weather, that the odds are we're going to have 2 snow closings 2 months in a row. But you just have to kind of keep that 90-day trigger in mind on appeals.
Super, thank you. Okay, so do I have a motion to adjourn?
So moved.
Do I have a second?
Second.
All right, any discussion? All in
No.
favor?
Aye.
Any opposed? Meeting is adjourned. Thank you very much. Thank